I hope you got the point listening to David Roden earlier on. He's not an Australian, he's not a Brit, he's a New Zealander, like me, a Kiwi expatriate who's long since flown the coop. Now, he grew up, I understand, in a place called Hamilton. Not a very promising name for a hometown. My hometown, on the other hand, is Wanganui, which means stinking hole in the Maori language. And perhaps helps explain why I've spent most of my professional life in the most dangerous city in the United States. I had a brilliant idea. I mean, one has brilliant ideas on these occasions, and they don't always work, of course. Many of my brilliant ideas don't work. This brilliant idea was to write a paper. And I wrote a paper, and there were some copies of it up the back, and I hope you'll read the paper. It's a decent paper. It's a first draft. It needs a lot of work, and it's far longer than anything I can say in 20 minutes. So I'll say a bit of that, and I'll say a bit about some other things that aren't in the paper. The bright idea I had was to go back and read the Nuremberg judgment, but more important, go back and read Justice Jackson's account of the London conference at which he drafted the Nuremberg Charter. Because, as you might have gathered, I've spent a decade or so of my life trying to get on top of a definition of aggression. Now, 11 years actually. Hans-Peter Kohl was there at the beginning of that too, and there are probably others in the room. And misery loves company, and I realised that Jackson had spent some time on this. To be fair, he spent only a month or so in London, and he was travelling a bit through that period, and then another year at Nuremberg. So I'm now a decade ahead of him in terms of time that I have spent on it. But he left tracks. He did explain what he thought he was doing and what he thought the other people were doing. Now, there's one other little piece of underbrush I should sort of push aside. I speak to you as a criminal lawyer. Now, I'm slightly fraudulent in that respect, in that while I have taught criminal law since 1964, I haven't practiced an enormous amount in the area. But that puts me well ahead of Jackson, because I checked with Greg Peterson, the ultimate custodian of trivia relating to Jackson, and he said that in the records there seemed to be about 3 cases in the New York system circa mid-1920s where Jackson did a little criminal law. And I assure you, ladies and gentlemen, it shows. If you read the transcripts from London, there's really only one criminal law there, the Brit whose name was mentioned earlier on, Sir David Maxwell Fyfe, who had tried some criminal law cases and tried desperately to explain a bit of criminal law from time to time to the others. Let me tell you what I think is the big issue in defining the crime of aggression, then and now. Here we have, and this is Tom Frank's point from lunchtime, really. Here we have a classic example of state responsibility. An evil state, a criminal state, if you like, which has done something terrible, and there's that responsibility. And also there's the notion that we want to use the criminal sanction against certain individuals who acted in the name of the state, in a broad sense. How do we move from the State Act to the Individual Criminal Act? How do we find the State Act? How do we define the Individual Act? And what are the connections? Now, in particular, in London in 1945 and now, one might characterise the fundamental drafting issue as whether there should be a genuine effort to spell out in detail the mens rea and actus reus of the offence. There I go, the criminal law phrases tripping off the tongue. The mental and physical elements of the offence as we describe them in the Rome Statute. Should we try to do that? Or is it enough to leave it to the judges with at most some general references to relevant sources. Let's say the Kellogg-Briand Pact, that they might take into account. Or, on the other hand, should we just leave it to them to figure out with practically nothing to go on? Now, I have to say that I couldn't find the words mens rea or actus reus once trip off Jackson's tongue. I couldn't find him talking about what the basic principles of criminality were, and he didn't get much help from everybody else who was there. And his thinking sort of hovered from the lay it out to the lay some of it out to forget it, put it in the too hard basket, and ultimately that's what the Nuremberg Charter does. Once you start asking yourself about that, what is it that the state did wrong? I'll explain in a minute some of the details that Jackson started with and tried to sell to the multitudes at London and failed. He gave up and settled for war of aggression. Unfortunately, he never explained what a war of aggression was. The Nuremberg Charter doesn't explain what a war of aggression was. And those who insist on putting war of aggression in the current negotiations won't tell me exactly what a war of aggression is. And I'll come back to that in just a moment. How do you make the connection between that war and some individual functionary? If you look at what Jackson had in mind, his main thing was a conspiracy doctrine. Talk a bit more about that later. He wanted to connect them by means of some notion of a conspiracy. Not a concept that the Russians or the French understood, and frankly, I'm not sure how well Jackson understood it, although later on the Supreme Court of the United States, he was very critical of it, thought it was a terrible idea. Maybe he learned from experience. Maybe in 1945 he thought it was the absolute best thing imaginable to connect everybody up. Jackson did think about something else. And I don't think he had a concept in his head of the structure of a crime. Crimes generally come along with some sort of conduct and what people do, some kind of results, and some kind of circumstance elements. And then you can throw in some kind of defences, what my country person earlier referred to as justifications or excuses. I don't want to get into the justifications or excuse debate, and indeed we ducked that at Rome by talking about grounds for the exclusion of criminal responsibility. Try to get an American lawyer to explain to you sometime what the difference is between justification and excuse, and then run it by the Austrians. Not a very profitable exercise, but at all events, Jackson understood that some people would turn up in court with justifications or excuses, or both, and that judges would feel constrained to listen to them. And here are the sort of things I think he must have been thinking about. What defences are open to the defendant of a nature that are personal to him or her? For example, mistake. Oh my goodness, I thought it was a just war. Oh my goodness, I thought we had an adequate resolution from the Security Council. Goodness gracious, I thought they were massing forces on the border. What a terrible mistake. Mia, oh! That's called an excuse. Alternatively, you could say, I wasn't there. I think it's called an alibi. Excuse me, but when Hitler and those guys were meeting, I was off skiing in the Austrian Alps. Not me. I wasn't conspirator. Come on. No personal involvement, whatever. It's got to be the case that people could raise those kinds of issues. And indeed, if you look at the Nuremberg judgment as it applies to individual people, quite a few of them pulled that off. Not me. I may have done this or that, but I wasn't part of the aggression team. Excuse me. I might have been guilty of crimes against humanity, might have been guilty of war crimes, but not that one. Not the supreme crime. What about the person who comes along and says, all right, I did it on behalf of the state. Now Jackson Co thought of that, and they put it in the charter. They said, no, it's no defence to say that you did it on behalf of the state. Bad. Got that one out of the way. What about the person who comes along and says, I had a superior order. Hitler made me do it. Hitler did. And they cut that one off. That's in the charter too. It says, no defence to say superior orders. Now the tribunal goes around a bit in circles about exactly what that means, but the charter is pretty plain. No defence. End of a story. Jackson, though, had applied his mind to another kind of justification problem, that of justifying what the state did. Now this is a real crunch one. Can the defendant turn up and say it wasn't an aggression because, easy because it was self-defense, or because I had a good reason for doing it? Now he thought about that, and he put a provision in one of his drafts about it, and he lost. It got taken out as the negotiations went along. Now I've got that off my chest because I'm going to run out of time, and when he says 20 minutes are up, I stop. But I wanted to go in a little more detail to some of what I've just been saying. Article 6 of the Nuremberg Charter provided a relevant part for crimes against peace, namely planning, preparation, initiation, or waging of a war of aggression. And then there's an or war in violation of international treaties, agreements, or assurances, another common, or participation in a common plan or conspiracy for the accomplishment of the foregoing. Now, as I say, a major element of this, a circumstance element, if you're into criminal law, is a war of aggression, totally undefined. Figure it out for yourself. So substantially is the question how you connect A, B, C, and D with that war of aggression, other than through the conspiracy doctrine, or because of those other verbs, planning, preparation, initiation, or waging of a war of aggression. Now I take it that foot soldiers and the janitors in the State Department, the Ministry of Foreign Affairs, are not in the business of conspiring to do an aggressive war. They're probably not in the planning, preparation, initiation, or waging business, but between the janitor in the Ministry of Foreign Affairs and the Minister of Foreign Affairs, who on earth does this catch? Doesn't tell you. You've got to guess in some way about whereabouts in the policy-making system, the governmental system, you cut all this off. How long have I got?
7 minutes.
Eh? Well, good. In his last effort to be comprehensive in his drafting, Jackson suggested a text for what an aggressor is. By that I mean a state aggressor. The state, and he was much more concerned about this part of it because he wasn't really thinking through adequately anyway, the criminal law part. An aggressor means a state which is first to do any of the following. 1. Declaration of war upon another state. 2. Invasion by its armed forces with or without a declaration of war of the territory of another state. 3. Attack by its land or naval forces with or without a declaration of war on the territory, vessels or aircraft of another state. Then he had another provision. No political, military, economic or other considerations may serve as an excuse or justification for such actions. but exercise the right of legitimate self-defense, that is to say, resistance to an act of aggression, or action to assist a state which is being subjected to aggression, shall not constitute a war of aggression. Now that's part, but not all, of a treaty that the dreaded Soviet Union had drafted in 1933 to spell out the Kellogg-Briand Pact, the London Treaty of 1933. And there's a history to it because a lot of that material resurfaces in the General Assembly's definition of aggression in 1974, which is a major part of the negotiation on defining the crime of aggression. How do we know what a state act of aggression is? Let's look at the General Assembly's 1974 definition, much of which goes back to 1933. And boy, does history repeat itself. Because when Jackson put that in, he dropped off a couple of paragraphs of the definition. And when a lot of the current players in the negotiation put in Resolution 3314, the General Assembly's definition, they cheerfully lop off 3 or 4 of the paragraphs and say, well, that's okay, you can do that, but it's only this that amounts to an aggression. Dodgy business figuring out what the state part is. Now, Jackson, when he introduces this, is very kind to the Soviets, and in particular to Professor Trainee, who'd been writing about this stuff since the mid-1930s, and who really believed in the notion of crime, of aggression, long before anybody in the United States thought it was something they really wanted to plug. One might have thought that the Soviet Union would rise to the bait, but they didn't. And as I think it was David Luban said earlier on, what they wanted was something referred particularly to the Axis guys. They said aggression against, God knows what aggression is, or domination over other nations carried out by the European Axis powers in violation of treaties, agreements and assurances. Now, they made the connections all right. The Axis people did it. We try some of the Axis people. The only question is what the penalty is, and make sure we got the right people. So presumably if you say, oh, no, it wasn't there, and you believe that, then they're not guilty. But if they're guilty, then mete out the penalty. Jackson seems to have had another agenda, which of course is the agenda doesn't apply as a definition to everybody for the future. And he got that. He just didn't get an explanation what is a war. Let me just finish on this note, because I think it's a fascinating one, isn't it? You know, it stuns me going back and reading this stuff that there wasn't some nagging person there who's put up his hand and said, sir, please sir, excuse me, what's a war? Because I like to think had I been there, I'd have been that really annoying, the truly annoying person asks you that question and says, what's a war? Because when you come to look at the result at Nuremberg, they got all hung up on those things called invasions that Jackson had in his earlier drafts. Think Austria, think Sudetenland, think Bohemia, think Moravia. Goering says, submit or I will blow the most beautiful city, Prague, off the earth. No problem. The Luftwaffe's up to this. We'll do it. And Prague says, okay, in you come, bring in your troops. No aggression as defined by a stroke of the pen. It doesn't come within it. Now one might have asked, why? There's no explanation where they moved from the invasions and so on. Control Council Law number 10 includes that language about invasions, and there's some prosecution for it in the second round of Nuremberg trial. Stunning. Nobody explains why they did that on the record. So let me just repeat so that I make sure I get my point across. The big challenge with defining aggression is twofold. How do you describe the state act, and how do you describe the connections of the individual with it? We've got a wild card in the current negotiations, which is what's the role of the Security Council. not a total wild card. This is not unlike what the Soviets were up to in 1945. They said, we defined this in Potsdam. It's what they did. It's not what somebody else might do in the future. It's what they did. And a lot of people think, well, it's only an aggression if the Security Council says it's an aggression. Now, my simple criminal lawyer's mind, it's a nightmare trying to wrap a criminal offence around an important element to decide somewhere else. If you do, you've got to think very hard about exactly who it is you're going to convict. You've got to think very hard about mistake of fact, mistake of law, and you've got to hang an enormous amount on those kind of ideas that nobody really talked about at London, or indeed resolved in the Nuremberg judgment. Thank you.